Okay, so Dr. Hess, he was here yesterday, but I'll also do another introduction for him. He's the clinical director for the State of Iowa Department of Health and Human Services and an adjunct clinical professor with the University of Iowa Hospitals and Clinics Department of Psychiatry. He's a licensed psychologist in Iowa and Illinois and a licensed attorney in California. His professional practice focuses largely on health-based policy, program development, and best practices for specialized populations like persons with complex needs and those in legal and carceral settings. And are you guys coming up separately? Is it okay if I introduce you now too? Okay. And Dr. Theresa Clemmons earned her medical degree from Des Moines University and completed her psychiatric residency at the University of Iowa. She has dedicated her career to treating serious mental illness in underserved populations, beginning as a board-certified psychiatrist with the Iowa Department of Corrections. There she recognized that many of her patients faced both mental illness and substance use disorders, leading her to obtain additional board certification in addiction medicine to better serve individuals with dual diagnoses. During her tenure with the Department of Corrections, Dr. Clemmons advanced to the role of mental health director, overseeing psychiatric care across the correctional system. In early 2025, she transitioned to the Iowa Department of Health and Human Services as psychiatric director, where she focuses on improving behavioral health systems through enhanced access, education, and policy development for the people of Iowa. So please join me in welcoming Dr. Hess and Dr. Clemmons.
Thanks, Lori. All right. Good morning, everybody. Two quick things I just want to give shout-outs regarding what Michelle spoke about and the National Center for State Courts and sequential intercept modeling. Number one, that listserv that she talked about is my favorite listserv I've ever received or accessed for this type of work. Not only do I find something relevant to read, usually multiple things every issue, I share them with other people throughout the state. I think it's that good and that relevant and applied in your work. It's not just theoretical and scientific articles, it's actual tangible stuff that I think you can work with. Number two, the sequential intercept model is really exciting. I'm really excited. It's something that we've talked about at HHS for several years. I know some of the local communities have talked about it and done it. To have this continue to expand across branches of the government is really exciting for Iowa. And I'll tease this, we're not talking about it today, but there is some scholarship out there that is in development for how this model can actually be a public health model. So it can be completely removed largely from this unique how people get involved with justice systems or legal systems. It can be actually a much more preventative and holistic frame as well. So again, I think a lot of utility in our spaces. So I'm excited that we'll have the opportunity to engage with that work as we go. But here, we're going to talk with you a little bit about, this is kind of a half hour of power here. We're not going to dive in deep with all the big, massive hours of discussion we could have on competency to stand trial across the country. What we are going to focus on is the, I think, proactive work that Iowa HHS has been involved in over the past handful of years. We talk a lot about being reactionary in our work, and we have this ideal of, man, wouldn't it be cool if we could get ahead of a lawsuit, get ahead of a crisis, and actually be able to set things up that we think are aligned with science and best practice and that will actually work for Iowa without having someone like the courts or a monitor come in and tell us what we have to do, like the True Blood lawsuit that out of Washington State that was discussed yesterday afternoon. So that's kind of what we're going to highlight today. This is really personally exciting for me. As Lori mentioned, my background before moving to Iowa 6 years ago was as a forensic psychologist, both doing assessments in multiple systems of care, levels of care, and then teaching in academia at a master's and doctoral level in Chicago. So when I came to Iowa 6 years ago, I had some fun kind of poking at some of these issues, learning more about where is Iowa at in these spaces, how do we do this work, and how can we then begin to expand it to make it better. And then having the opportunity to collaborate with Dr. Clemmons over the past now, my gosh, it's almost 9 months, is incredibly exciting as well. Again, as Lori mentioned, she came from Department of Corrections as their medical director in IMCC, so has some really unique experiences on that side of the system as well, and we're going to be incorporating that here. So the way this brief talk is going to work is I'm going to kind of give you a background for how we got here today and why we approach that work, to give you more of that systemic outline of what developed, why it developed, and where we are today. And then Dr. Clemmons is going to fold in some, do you like that? Fold in some data for where HHS and we got some DOC data, IMCC is at over the past handful of years. And then we're going to tease some considerations. These are not things that HHS owns. Again, what we're talking about here is a statewide problem that is bifurcated across 3 different owners, across 3 different levels of care, with no centralization. We're not saying there has to be centralization or more coordination, but we do pose those questions for all of you to think about, because again, as we've talked about throughout this summit over the last 2 days, we can't do any of this without all of us. And I think, as you'll see here today, all different systems of branches of our government, levels of care will impact this work here that we're talking about with competence to stand trial. So a little level setting here for y'all. When we talk about competence to stand trial, the outpatient competency restoration team at Community Support Advocates in West Des Moines talked about some of this yesterday in the context of their outpatient program. But just want to level set with you to understand what we're talking about here. Number one, competency restoration is not whole health, wellness, I'm going to get to the root cause of your problems. And if you're intending to use it as that, as an attorney, as a law enforcement professional, or as a judge, we're misguided, right? So that's number one thing. Restoration is really designed to get the person to the low threshold, it's not that high of a bar, so they can fairly go through with their adjudication, right? So they can maybe plea bargain or go to trial and have that process work through. It's nothing else, right? Now I'm going to talk out of the other side of my mouth. However, at the same time I say that, I believe that in our different spaces and levels of care that we're going to talk about today, we can all do more to make it so we can connect people back to their local communities to get the actual whole health, individualized care that they need to get out of that revolving door. So I say that, and I hope you're not sitting here going, man, that guy likes to talk out of both sides of his mouth. That's not what I'm trying to do. It is nuanced. But I think it's important to know that for people trying to get people access, don't use this route. It's misguided. We need to use other routes, more upstream, actual preventative routes that are going to get at this issue. And at the same time, as I'll tease a little bit with the outpatient program, because it's actually the aspect of the program I'm most excited about, there is more that we can do and need to do to connect people to the behavioral health care and other services and supports like stable housing that they may need to get out of this cycle, so we stop seeing them in our courtrooms, we stop seeing them picked up by the same law enforcement people, often for low-level type offenses, and getting looped up in this system. So with all that said, we have different aspects in this arena of competence to stand trial. Number one is competency evaluations. That's the initial step to determine, is someone competent or not, yay or nay. That's defined in Iowa Code, Chapter 812.3. Interesting thing about this, these evaluations typically occur while the individual's in jail. They may have been released. Apparently this is very interesting if you know, and you can go check to our Polk County Sheriff or Polk County Jail colleagues. Roughly I believe about 50% of those who are detained in Polk County Jail are released within 48 hours, give or take, right? So again, within a day or two, you were losing half of that swath of individuals that come through that door. So you have individuals that are now out in the community who now, as they're going through their trial process, may not even be flagged for possibility of incompetency in this space, right? So you have that initial space. Generally, Iowa Code does not clarify who pays for that service. If you have financial means, generally you're going to pay for that service, and maybe through your attorney. If you're indigent, the state public defender and the defense attorney, if you're indigent, you have a public defender, defense attorney raises concern about possible incompetence, the public defender will pay for that initial evaluation. Over time, we have different contract private evaluators who do this work throughout the state, and if they need a facility, historically they've been routed to IMCC to do that work. Once an individual has been deemed incompetent by the judge, they're then sent to restoration. We'll talk about this. We now have 3 levels of care for competency restoration in the state, which is exciting. This is really based on dangerousness, right? So the judges, it's not based on what's available, who has a bed, it's based on dangerousness. So if they're nonviolent offense, non-dangerous, and willing to participate in restoration, now that we have this outpatient restoration program, that is also starting to serve youth. If you noticed that yesterday, for those who weren't here in the afternoon, that program is starting to serve youth, which is phenomenal. That's the least restrictive space for those individuals. You can imagine things like housing, things like care coordination, things like transportation may make it challenging for that person to engage in that service. But if they can, That's the first, less restrictive option. If they are unwilling, they're still detained, say in jail, they're unwilling to engage voluntarily in restoration, but they're still not, quote, dangerous, then they can go to one of our mental health institutes that are operated by HHS. We have the adults go to Cherokee MHI, and we have the youth go to Independence MHI. However, if they're then dangerous, otherwise have challenges, that's where they get routed to the 14-bed facility, the Forensic Psychiatric Hospital at IMCC. There is a caveat here. You might be wondering, why do dangerous folks have to go to IMCC? Doesn't the MHIs inherently treat people who are dangerous every single day by psychiatric commitments? And you're absolutely right, they do. However, Iowa Code 812 does distinguish those levels in that space. So yes, MHIs serve dangerous people for civil commitment. The way the code is written, if they're too dangerous for competency restoration, they go to IMCC. Within this whole space, we have another type of civil commitment that is somewhat related at times. That's Iowa Code Chapter 229. That's civil commitment for dangerousness to self or others, or, as people talked about yesterday afternoon, which is underutilized in Iowa, unable to care for themselves, or sort of gravely disabled in those spaces. Where we often see that come up is if we have individuals who are found incompetent and then ultimately found not restorable, which means we can't regain that competence within a reasonable amount of time, but they're still dangerous, they can't be safe to go in the community, they may be pushed into the civil commitment process under 229. The last sort of related group of people, class of people here that we want to distinguish are those found not guilty by reason of insanity, or NGRI. That's the Rules of Criminal Procedure 2.228. You often, if you're familiar with it, refer to it as 2.2. These are individuals who were deemed insane at the time of the alleged offense. That's a historical static look in time. If an individual is alleged to conduct an illegal act on January 1st, 2024, all I care about when I'm doing that evaluation is their mental state on January 1st, 2024. I don't care about it right now on September 12th, 2025. Competency is different. Competency is current, present state, right? We don't care about what their mindset was at the time of the offense. All I care about is right now, do they have the capacities, the understanding, factual and rational, to fairly participate in the legal process, right? And we know that that can change every time. It doesn't change rapidly like this, but if a hospital stabilizes them, right, and then sends them back to a jail, and they stop taking medications or have other stressors that lead them to decompensate, they are now incompetent again, and what do they have to do? Whole process over, right? Taxing on resources, taxing on their behavioral health, and those sort of aspects. You haven't been able to hear a conversation or a training or anything like that on competence to stand trial without hearing about what we call the competency crisis. When I mentioned proactive work, Iowa is in a fortunate state right now, loudly knock on wood. We do not have what we call one of these true blood type lawsuits, which is a lawsuit suing a state for excessively long wait lists for evaluations for competency, or most likely long wait lists to receive the restoration that has been court ordered. There are about 16 states in the country that are under these lawsuits right now. Iowa, thankfully, is not one of them, and I'm optimistic that we have prevented such a successful lawsuit from happening, given the system of care and the work that continues to go on in these spaces. But as I mentioned, we've seen a rising demand of this across the country. This is why there are less psychiatric beds for people who are, quote unquote, civil commitment, danger to self or others, because the high majority of state psychiatric hospital beds are being taken up by forensic-based patients. The national average is about 50%. Texas, closer to 75%. Iowa, actually I can't tell you what it is right now, but before we started this work, including IMCC, we were much closer to that 25 to 35%. Again, we're trying to get ahead of it and stay ahead of it. We can see down the road what's happening and what's coming. We have states like California, not because they're liberal, but because they're the 5th largest economy in the world, that they see things in their society sooner than other jurisdictions. And we can go back a decade and see across other states, not just California, that has seen these things a little sooner. And so when you look at this graph here, you'll see the first one shows the relative increase across the country, right? That was a series of states that combined to see their general increase. So we're seeing an increase across the country of about 37% between 05 and 14. We're seeing a drastic increase over the past 5 years in HHS. This shows what we have leaned into. This is intentional. We have leaned into this because it's a state problem. We think we can contribute in a positive direction. And the reality is, HHS or similar organizations across the country in different jurisdictions are a main hub for this work. DOC often plays a part in secure facilities, especially, maybe in some evaluation work, but this is normal. This is part of what we should do as an agency, as an organization. It's part of what the safety net provides. Why? Because no private hospital in the community is going to do this work because of the perceived risk. But I have something to tell you. We've ran some data for assaults. We've ran data on injuries. This population is much less risky in your hospitals than 229s are in terms of the acuity in those spaces. So in terms of reducing fear of this group, I hope that helps reduce the fear. Also to understand, yes, you can be incompetent to stand trial. You can be floridly psychotic. And you can be safe to live in the community all at the same time. That seems very foreign to people, but that is a true thing. And the outpatient restoration program is an example of that, even though they do focus right now on nonviolent individuals. Again, I just frame up, there's other jurisdictions in the country that do this modeling, that with the right services and support, you don't need a facility to do this work. But if we do, we have different levels of care in Iowa to provide it. Oops, let me see here. There we go. Whoops, I don't think I did that right. In terms of where we're at with this space and what we've done here, and then I'm realizing I'm going to speed through. As I mentioned, this was all intentional. So we started this by making a data-informed decision. We came in and we started gathering data. First, we created a survey of, first actually, we pulled some data from the judicial branch. And we reviewed all of the incompetency orders from 2017 to 2021. And we realized that we have about 200, 5 years, was it 200? Yeah, I think about 200 competency evaluations, give or take, a year over that period. And we have about 75% of the restoration work comes out of one place in the state, Polk County and District 5. Right? It's the most largest concentration. It's not the only place, but it's the largest concentration. We then sent out a survey to all about 95 jails in the state to get a sense of how are you medicating in jails, to get a baseline of, because we know that we can do great work at IMCC, we can do great work at Cherokee and other places, but if they're not continuing that care in the jails, it's going to fall flat. We have to get a sense of what's going on there. So all the jail-based behavioral health work you heard about yesterday, you can see conceptually and systemically is related to this work here, and all coming together to make sure it all works in the end. We took all this data, we had conversations, we met with IMCC, we met with local folks, we met with sheriffs. We had some really hard, difficult discussions. And then we landed in a space where we go, we're going to do some pre-file legislation to help make this work happen. And we had 2 edicts that we had to meet. This is classic government. I say that with all non-judgment. One was you have to expand capacity of youth beds in the state. But here's the kicker. You can't expand the total number of beds in the state, and we're not giving you any money to do it. Go. We also want to stay ahead of this wait list problem that we see bubbling at IMCC, and we don't want to have another lawsuit because we have too many already in the state. We want to be able to do good work and put our resources proactively where they're needed. We put that together, and this is what we came up with. We decided that, one, for outpatient restoration, it always existed in 812. The problem is it didn't say it was mandatory, and it didn't say who should pay. We fixed that glitch. We made it mandatory, and we decided that we will pay through pass-through once the levies went away, state appropriated, right? We then work with Polk County. They develop a dynamic RFP. Colleagues at Community Support Advocates applied, won, now provide that service. Number 2, we decided to specialize care at our MHIs. We moved the youth beds that were scattered across multiple psychiatric hospitals, we moved the youth to independence. So we expanded our capacity for youth beds by 8 by making that move. Yes, it did decrease the adults. We cut the adult beds at MHI in half, and then what we did was we said for Cherokee, we're going to designate and reserve at least 12 of 36 beds for forensic patients. Here's the thing, though, as the data will show. They've been clearly serving way more than 12 patients at any given time. That number is much closer to 17 or 20 at any given time since we've started to do this work. And so again, we now have 3 functioning levels of care for restoration. We have a more specialized focus where we think that will help with training competency. So we don't have jack of all trades, master of none. We now have a space in Cherokee. They are doing core evaluations and restoration for adults. Independence is doing the broad space for youth, including restoration if a youth needs to go to that level of care. And again, we now have our outpatient program, which again, as was indicated yesterday, is statewide, folks. We started it in Polk County to get it going because we know, as I mentioned, About 3/4 of the work is coming out of that area anyway. But as we mentioned, that is statewide. And the thing I am most excited that I think is most innovative about this work, I wish I could take credit, I can't. It was the other folks at Polk County who came up with it, and now this is CSA that's delivering it, is the connection back to the local communities. It's deliberate and intentional. It's required. No longer can they say, oh, not restorable, gone, we're going to loop them back, or yep, they're going through the process. Either way, there's still a deliberate connection back to their behavioral health district to force that area to say, hey, you need to loop up with this person, connect with them. Even if they go through and they get incarcerated, put them on your list. Give them the services they need to get them out of this bind, right? Overall, and I'm going to move on, I'm going to kind of skip over this because we kind of hit the aspects of outpatient restoration, again, the levels of care, and the overall development and coordination of this space. And I want to make sure we give Dr. Clemmons enough time to talk about the data. But what we have here, again, is really a summary of what we talked about here. This was a deliberate process, a data-informed decision process, where we collaborated with external stakeholders to get a sense of what's going on, and then how can we in our spaces with partners begin to chip away and make this process better and more effective. One thing I didn't mention here, but we do have, and I actually need to update now that OCR is serving youth, is we have a quote-unquote bench card. It's more of a guide that now that we have 3 levels of care, it's designed to help judges make more informed decisions, right? Because now that judges have more options, we didn't want to leave them in the lurch of being like, well, how do I know whether someone should go outpatient, MHI, or IMCC? So we have a guide out there that you can email me. I'll share it with all of you. Again, we'll update it for adults and we'll create a youth version too to clarify how you do this. And this is, again, it gives them clinical indicators to link up with the vague legal benchmarks of dangerousness and things that the judge can actually sit there. There were some Dubuque folks. Or was it Davenport? Which one? Sorry. Dubuque? Dubuque, right? Excellent. Sorry. Yesterday, who spoke and talked about how they have people languishing long time in their jails. I may regret saying this, but people need to know it. Those decisions, again, are based on dangerousness. We also have a long history of funneling all these cases to IMCC. I don't think the system is caught up to realize we have less restrictive levels of care. If that person is no longer dangerous, they don't need to be on that wait list for IMCC. You can have the judge change the court order them to a different level of care. Maybe Cherokee, maybe outpatient, even more ideal, right? Again, this is statewide. We have done telehealth for restoration with the provider in Ames and the individual at Vera French. Ultimately, it didn't work because of that individual's functioning, but we gave it a go, and we have those things that we could put together. So again, I highlight that broad scope to kind of address some things there, but now I'm going to kick it off to Dr. Clemmons, who's going to cover more of our data to show what we've done and then tease the considerations for further discussion. Thank you.
Awesome. Perfect. Thank you. All right, let me go ahead and put my paper here. So I'm just going to kind of run through some of the data that I can show you both from the Department of Corrections through their Forensic Psychiatric Hospital, and then Cherokee Mental Health Institute through HHS. All right. So this one just really shows kind of the length of stay and our inpatient admissions at both facilities. As you can see from this, the tables are a little bit different. So primarily at Cherokee, they had people come in for restoration, they're admitted, and then we kind of show again their length of stay. At the Department of Corrections at the Forensic Psychiatric Hospital, they actually do some outpatient forensic evaluation, so those 812.3s, and then we do all our restoration work in-house when people are admitted. The reason we split that up at the Department of Corrections, and it happened about a year before I became the mental health director there, was essentially to help kind of, again, get ahead of this increasing trend for these orders, these referrals for services. So essentially, instead of admitting somebody to the hospital and doing their evaluation and taking a bed in that space, we go ahead and just do it over a period of a couple hours on an outpatient basis. Again, so that way we kind of keep those beds open for those 812.6 restoration type work. As you can see from this, and I'm actually going to get a little bit into graphs of the same data here in the next couple of slides, but essentially we kind of show a trend that back in 2020, we had very, very long length of stay, a lot less admissions, and then over the last couple of years, we've actually really sped up in terms of our number of admissions we've had, and then also decreased the length of stay as well. I have the averages up there, and really you can't compare the Forensic Psychiatric Hospital to Cherokee directly because they serve kind of different populations. And they also serve different levels in terms of, if you think of dangerousness, sometimes the most severe individuals, the ones who are most dangerous, can take a little bit longer to restore. So again, just can't necessarily fully directly compare the data between the two, but I definitely wanted to put it up there so you guys can see kind of what work we're doing in both hospitals. So breaking it down a little bit further, Cherokee does serve the 3 types, like I mentioned. They serve the 2.2, not guilty by reason of insanity, the 229, which again are inpatient civil commitments for those individuals who need involuntary treatment for mental health, but again, they're not facing any kind of criminal, typically not facing any kind of criminal charges, and then the 812s, which are the ones that are specifically for competency, restoration, and evaluations. And so over time, as you can see through this graph, is essentially that we've actually increased admissions for the 812s in both settings, both the Forensic Psychiatric Hospital in IMCC and then also the one at Cherokee as well. But as Dr. Hess mentioned, we've also then had to somewhat decrease some of our 229s. Again, if we're using those beds for 812s, we essentially haven't expanded all of the beds we have, and we actually decreased the number of beds for adults, and so we've had to actually decrease a little bit of that 229 work. The nice part about 229 work is it can be done at any hospital, or it can be done at outpatient in the community clinics as well. So by focusing the resources, the 2 places that we can do the 812 evaluation or restorations, we've definitely had to kind of decrease the number of 229s we've had to serve. But over time, over the last couple of years, we have increased the number, again, to get ahead of this competency crisis that we've seen kind of looming both in our state and then also nationwide. So this one shows length of stay. So 2020 obviously was a very, very interesting year. Length of stay was really, really high for probably a number of reasons, the pandemic probably being the biggest reason in that case. But as you can see over time, the length of stay has also decreased. And that's through some of strategic kind of planning. We've gotten in people to do educational didactic work with individuals. Because again, competency is not just fixing and treating the mental illness that's at play, it's also providing the education to these individuals so they can be competent to stand trial. So they know what the judge does, what the jury is, what a plea bargain is, all those types of that terminology, that judicial knowledge, we also have to teach them as well. So we've gotten in these experts to go ahead and provide this type of education. We've bolstered our ability to now get people in to get their reevaluation faster. So when someone comes in, they're incompetent to stand trial, they're here for restoration. Of course, we diagnostically figure out what is going on. But towards the end of the restoration, when we think they're ready to go ahead and go back to the jail or go back to the courts, we need to basically prove that they are now competent to stand trial. So again, this was also a backlog as we didn't have enough evaluators in our state to be able to then do this post-evaluation to ensure that when somebody leaves the hospital, goes back to the jail, they are now ready to go ahead and proceed with their criminal processes. So basically, strategically, through both DOC and HHS, we've been able to be more efficient with our multidisciplinary teams and then also decrease that length of stay so that way we can serve more people as well. So a little bit about outcomes. So the question is, okay, we're doing this restoration work. What are we really doing in there? Who is restored? Who is not restored? So I have the data from Cherokee. This basically shows that 53% of people are successfully restored to competence. So when they leave our hospital, they are good to go. The data here is a little interesting on how we did this data set. So there's no standard way to do these data sets, but there was also still individuals who were still hospitalized at the end of the fiscal year of 24. So they're included in this chart, and that's about 21%. And then about 25% of individuals we were not able to restore to competency. So basically, not competent, not restorable. And in those cases, the court has to make a decision on what to do with those criminal proceedings. So at the Forensic Psychiatric Hospital, again, this data set's a little bit different from Cherokee. We didn't include the individuals who were still inpatient at the end of that fiscal year. We basically just showed kind of what the results were for anybody admitted within that fiscal year of 24. So 76% were restored to competency, and then 6%, as you can see there, sorry, it's really tiny on there, we're kind of this other category. And this other category is pretty interesting. It's usually individuals who just aren't participating in the restoration work. So we can give them medications, we can provide the education, but there are some individuals who are malingering, and they simply won't participate in any of the evaluations, they won't participate in any of the didactics, and those types of things. Other people have organic brain injuries or diseases. And so those individuals, sometimes we have to do more testing, figure out really what's going on, because we're not able to restore them, but we're not sure if we can restore them. And so again, sometimes these individuals are actually referred to a medical team to undergo some testing, some different types of workup to determine if that individual can be actually restored to competency. And then about 18% of people we weren't able to restore. So again, not competent, not restorable in that as well. And so that is an outcome that does occur. But the nice part is about 70% are restorable, and that's actually been shown nationwide. About 3/4 of individuals can be restored to competency. This last one kind of, again, just shows the number of days and the number of resources we're now putting towards this competency restoration. So if we look at fiscal year of 2025, we essentially had 4,781 days. And about 90% of those were related to 812 or 812.6 competency restoration. Again, because we're trying to get ahead of this, trying to put a lot of our resources towards that. And so that's where a major part of our work at Cherokee is, in addition to Forensic Psychiatric Hospital. So the next part is kind of the future considerations. As Dr. Hess mentioned earlier, is kind of what should we do at this point in time? And I think there were some really good points that were mentioned even earlier. You know, as mentioned, that jails have really kind of become the de facto mental health service in the state, which has really kind of increased these restoration orders. And so the question is, how do we get ahead of this? And I think one of the things I was thinking of when I was actually reviewing this presentation before giving it is part of it actually comes down to prevention and early intervention, getting people before they even get to the point of committing a crime, needing this type of service. That is not on this slide, but something to definitely want to consider. Other things that we're really looking at is, again, classification for forensic psychologists. If we have people who are forensic psychologists who work for the state, we really need to clarify and classify their pay level, so that way we make sure that we get people in who are quality evaluators, we can keep them with us, and then we're also being competitive in terms of pay grades across the nation, so that way we can keep them here in Iowa. Other part is outpatient restoration. This was already talked about, so I'm not going to belabor that point. Another interesting point is kind of that collaboration with the courts. So one thing that happens in certain spaces is we have to wait for those court orders to come in. If you have if you're doing a competency evaluation, they're in on an 812.3, and they're hospitalized. But now we need to actually restore that person. We determine they're not competent, but likely restorable. Well, we can't start that restoration process truly until we get another order from the court that says we can go ahead and restore this individual. And that can take time. And the more time that takes, the more that person just sitting on our inpatient unit, not receiving any kind of treatment. Additionally, in 812.6, there is actually no order to treat that's actually just inherently ingrained in that. The person can actually refuse treatment on an 812.6. And so we need to get a separate order from the court to essentially say, yes, you can go ahead and involuntarily treat this individual who needs this restoration work. And that can, again, take time. So we have individuals who are in seclusion, who are in restraints. We could only treat them through kind of emergency orders, again, if the person's dangerous, to hurt themselves, to hurt other people. So that's kind of where that collaboration, communication, and networking really comes in, is getting these orders in very, very quickly, and that way we can start the process much, much faster. Centralization, we kind of mentioned this. The question is, do we really need to centralize? Maybe, maybe not, but right now things are kind of patchy sometimes. Order can be over to FPH over at the DOC, but maybe they're not dangerous anymore, and now we need to get them over to Cherokee. Again, how quickly does this happen? Who's doing that work? Who makes the determination? Again, it's pretty patchy at this point in time, so the question is, if we centralize it, would it be a lot smoother process? And I'm sure in certain situations it is, and maybe in certain situations it's not. But again, something to kind of consider. The other part is just improved resources. Again, making sure that we're expanding diversion and deflection across Iowa, making sure that we are expanding assisted outpatient treatment, and then making sure that we're also expanding prevention and early intervention in these spaces as well, so we don't have to get to the point of needing to treat somebody when they're now facing a criminal charge. So with that, kind of give my references, and I did want to thank both Cherokee and the Forensic Psychiatric Hospital, the DOC, for providing these numbers and assisting with this presentation. So that's everything. Any questions? Yeah.
Can you wait for the microphone so people can hear you?
would it be more efficient if we have the courts include all of those in the initial request or order for an evaluation? That if it comes back that they are restorable, and if they need medication all at once, and then you just keep that person and do it then? Or do you need that cycle so you can get people in, like?
So when I was at the Department of Corrections, we often would actually ask the court to specify where they wanted the custody to go, because sometimes the court orders would say Cherokee Mental Health Institute or the Forensic Psychiatric Hospital. Now, we were told essentially through our legal team that we really needed to have the order specifically for custody at FPH if we were going to admit him to FPH, and I think they do the same thing at Cherokee, as we want it really specifically to that place, because they're two separate entities. In terms of the order for the 812.6, so when we get the restoration order in, if it already contained an order to treat, that is a lot simpler than waiting for that order to treat to come back in. And again, I'm not sure exactly why it's either written in the code that way or why it's not always included, but that would be a lot faster in terms of not having to wait for somebody to do that.
Yeah, it's actually, the reason is legal. There's a U.S. Supreme Court case, U.S. v. Cell, from like '03 or so, that in essence says if you can involuntarily medicate someone to, the Cell case said you cannot involuntarily medicate to restore competence unless you meet 5 specific criteria, right? And 812 doesn't reference any cell. You start to talk with a lot of attorneys throughout Iowa, they may be like, cell what? They're not familiar with it. But it is baked in where 812 allows us to, we can involuntarily medicate if they're dangerous or violent in the space, right? We can involuntarily medicate to get their compliance to participate in the initial competency evaluation to determine if competent or not. We cannot involuntarily medicate to restore competence unless we meet those 5 criteria. So legally, it's probably something we probably can't bake in presumptively on the front end, but I will tell you, I bet there are process and procedures, education that we could do, and we've shared internally. IMCC had a great letter that they used to use for those things. We shared it with Cherokee and Independence, so we're trying to help our own folks coordinate in that space, but yeah, to your point, related to centralization, there's probably some coordination work, education guidance that really could help in those spaces. Absolutely.
Hi there. So in Johnson County, we had a problem where when somebody was being booked into jail, somehow the physicians were knowing about that, and they were dropping the outpatient committals, which made it impossible then for the jail staff to provide the psychotropic medications that we all knew they needed. So we went back and basically did an education session, and me sitting there basically saying, please, please, please stop dropping outpatient civil commitment orders when someone's going into a jail, because if there were ever a time they needed to stay on their meds, that's it, right? Mm-hmm. So if that's happening in your communities, get with the docs that are dropping those commitments. That's inexcusable to let somebody sit unmedicated in a jail.
No, I appreciate that. Thank you.
I'll say one comment here as we're looking for other questions. What Dr. Clemmons mentioned regarding the, the forensic psychologists. We're really excited about this because this was a big thing. We worked with DAS, and we got rid of the psychologist job classification series. What that series did, psychologist, that was the name of it. That was the series in Iowa where any type of behavioral health clinician had to get a job for. So you work as a mental health counselor, a social worker may be a little different, behavior analyst. There was no job designation that was titled what you identified with, right? There was also, the salary structure was way too low for any legitimate licensed psychologist who specializes in forensic work to be hired. We're missing it by $40,000, right? It was drastic. And so what we did was we worked with them, we got rid of that series, we created a new behavioral health professional series with 4, technically 5 if you count the administrator designation. So the BHP4 is the level that I'd imagine a forensic psychologist, a neuropsychologist, some sort of specialization there would likely fit into. So I just put that up there. We tried to fix that glitch of now we have higher salary and more growth for master's level clinicians too. We can call it things that identify with people's field and background so we can recruit better. So it's a tool to kind of set the foundation for recruitment and retention. That's going to impact this just like any other specialized service throughout the state. But I think at the same time there might be, if you're sitting there like, oh, this is odd, I've never heard of this, HR I think is still working on some clarifying guidance in that space. So again, if you have questions, you can reach out. I can help maybe connect or coordinate.
right, I want to say thank you to everybody. And if you have any questions or anything, you can definitely email myself or Dr. Hess as well. So I don't mean to, I guess, throw that out there, but.
Yeah, absolutely. This one, not yours.